Hey guys, Brian here with Stogie Review, IPCPR 2016. I'm here with Frank Herrera of Cigar Law. You know him as Cigar Law, or you might know his cigars, the biography, things like that. But today I think we're going to mostly talk about the FDA and what's coming down the line. And I think you're uniquely qualified to fill us in on that.
Oh, I hope so.
Yeah. So what would you say is something that people don't know that they really should know?
When we say people, do you mean manufacturers, consumers? Who are we talking to here?
Well, I mean, I think a lot of our viewers are just consumers, but I mean,
Yeah.
we do get manufacturers too. But yeah, we can start with the consumer. What should the consumer know that they probably don't realize?
Well, there has been well, first of all, I want to thank you for the opportunity. It's been a while since I've seen you. You're clean shaven way back then.
I know, right? Yeah.
But the homeless thing looks good on you.
Yeah, I prefer to think of it as more of like a Viking thing. Okay.
We'll go with that.
A return from Valhalla to interview you.
That's more of an old cranky miner.
I get Prospector a lot. Yeah, I do.
So I know that your readers and your viewers are pretty knowledgeable. Well, as far as reading a lot of things that have been posted on social media and blogs like yours. And they probably heard that the FDA is deeming regulations, and they're probably under the assumption or have the knowledge that it's going to significantly affect the cigar industry.
For sure, yeah.
And primarily the boutique cigar industry. It's going to affect everyone, but the little guys are definitely decimated or crippled by it for sure. So, in the time that I've known you, I think 70 years or something like that.
Yeah, at least,
so,
yeah.
We've experienced, you and I, and others like us have experienced this kind of wave of boutiques and excitement in the industry.
Absolutely.
Neat packaging, great cigars. Forget about the packaging. We just, blends that are just amazing.
Creative blends, yeah.
Yeah, just creative blends. And that was, that came up in an environment of just freedom. An industry that was essentially not regulated. And we enjoyed that. And hopefully we can still enjoy it in some way, shape, or form, but the days of on-the-spot blending, releases, limited editions, and all these funky blends are gone. The new normal is going to take effect August 8th, 2016.
So on August 8th, no new cigars can come out unless they go through the steps set forth by the FDA. Is that right?
That's correct, yeah. So that date is significant because it's the effective date of the deeming regulations. And there's a possibility that date will change. There's a very slight possibility.
What would it take for that to change, do you think?
So from the legislation side of things, it would change, but it would be after that date that it would change. So that effective date may get moved. It may just get become not effective at all because of different things that are pending in Congress. But that's not going to happen before that date. The only thing that could really affect that date now is litigation. Whether it's litigation that our firm filed or that the IPCPR, CAA, and CRA filed. We filed in the United States District Court of Southern District of Florida, which is Miami, and we'll call IPCPR their group filed in the District Court of the District of Columbia.
Okay.
And either of us could move to court for certain relief that would stay that deadline, or move that deadline, or do a couple different things so that deadline doesn't kick in when it kicks in.
Okay.
So it may kick in later, it may not kick in at all, but it's going to take a lot of work to prove that.
So if it doesn't kick in at all, do you, in effect, kind of negate what's happening, or is it just everything will have a grace period and would have to still file, but they could still release it?
There's a lot of things that could happen. So the number one things that we're asking for in our case, and IPCPR is asking for, is that what's known as the predicate date, February 15, 2007, is moved. It's moved to either 8/8/16 or to another date that the court might find just and appropriate.
Okay.
So that would be the greatest result in this, because all these guys that have worked very hard in the past 9 years would not be in a situation where they're actually forced out because of the high cost of compliance, or just forced out because they just don't want to do it, or whatever the case may be. So that would essentially grandfather everybody up till now, 8/8/16.
Yeah, that would be nice. Yeah,
that would be awesome because people are okay with being regulated. They don't like it. They can live with it. The biggest concern is that it's just unjust and unfair, which are the same words, to retroactively go back 9 years for the clients.
So was there, I think we were talking earlier and you said there was some sort of I don't know if the word is the right, precedent that was set by, I think, the cigarette industry with how far back they go. I'm not aware, obviously, but, you know, tell us a little bit about that. That sounds really interesting.
So it wasn't a precedent, so I get what you're saying. So the date of February 15, 2007 was, it is not a significant date legally, or has some type of effective date because of public health or something. It was chosen because that was the date in which the Family Tobacco Control Act was submitted or otherwise introduced into Congress. It could have been introduced February 16th. That wasn't a Saturday or Sunday. It could have been, some other date. So the Family Tobacco Control Act, just call it the Tobacco Act, came out in 2009. That's when it was effective, and they gave cigarettes, roll your own, and snuff basically a 2-year look back.
Okay.
Right, and that's what we're talking about 2007.
Okay.
To be kind of a grandfathered situation. Now, what happened since that time till now? Well, a lot of things, and there's conspiracy theories and everything else, but essentially the cigarette companies said, wow, we're regulated, but there's a whole bunch of other tobacco products out there that are not regulated, and it's called the Tobacco Control Act. Hey, FDA, you need new deeming regulations, as the Tobacco Control Act authorizes you to do, to cover all these other tobacco products. Cigars, e-cigarettes, vapes, that type of thing.
So you're saying the cigarette company do you think was behind that?
I don't think that I know it.
You know it? Okay.
Yeah. I'm saying I don't think I'm a conspiracy theorist. I think the letters that Altria and Philip Morris and some others submitted to the FDA during the comment period proved that. And they said, hey, we're regulated. There's all these other people, regulate them. We want to share the user fees. We don't have to pay for all the user fees. We want them to pay for some of it. And by the way, the Act says tobacco. You've got a whole group out there that's not regulate them. And I think they didn't really care about cigars so much. They did care about e-cigarettes and vapes because they were taking significant market share away from them. And they said, get these guys in there. And they love that predicate date because if you recall, most e-cigarettes or vapes didn't even exist.
Exactly.
So they cannot qualify. So essentially, you just decimate that entire industry that was taking away market share from cigarettes.
So under that, I guess the government is viewing the vape stuff as tobacco.
Well, it's funny you should say that. So there's a couple cases pending in the District Court of the District of Columbia and the Central District of California, which is essentially LA. We have federal courts. And that's what they're saying. They're saying, I guess it's the vape company, EcoPure, I think they're at a 10 or something. They're saying, we don't have any tobacco in our product. I'm not sure if in one of them they said, some of ours do, but some of ours don't. For the ones that don't, you can't regulate it because it's called the Tobacco Control Act. We have no tobacco. You just cannot bring us under this umbrella. And then they have other arguments as well that are pretty sophisticated. Did I answer the question?
I think so. No, it makes sense that they would do that because I was thinking about it's like, sure, these things have nicotine. Some do tobacco. Yeah, that's true. Some of them don't. Yeah, and it's
and you can have nicotine from other products.
That's true. Yeah, I believe don't tomatoes have nicotine?
Yeah, and they argued some of that too. And I don't know, like eggplant or something weird.
Eggplant.
I don't know. That gets
such a buzz off of eggplant. So, what other things you mentioned? There might be some things that like the manufacturers need to know that maybe they don't know. So what would be some of those things?
Sure. So the consumer probably thinks when they go into a humidor, all these manufacturers are creating equal, but they're all of a relative education level, sophistication, and knowledge. But the truth is, as an insider, you, me, Ben, and others, we know that a good portion of this industry are mom and pops.
Yes.
Spanish speaking, many not even in this country, have no idea what the F is going on at all. And they're just making their cigars, and they have no idea that this tidal wave is coming. They're sitting on the beach, watching the waves roll in, and they have no idea that this entire tsunami is coming. It's just going to wipe them out and decimate them. Like victims of all tsunamis, I guess there are some that live most, depending on where you are.
Sometimes by luck.
By luck, and that's it, right? And then others by resources. They were in a hotel that was really strong or in a high floor because they're wealthy and they had the foresight. This could happen. So, the manufacturers that matter. I don't mean matter. That's a poor choice of words. The bigger guys know what's happening. They've known for quite a while, and they've had good counsel, and they start preparing the best they can, and they work politically, and so they're going to be okay. It's going to cost some money. They're already raising their prices to deal with this, but the smaller guys are really in a tough time. A, they don't know about it, or B, if they know about it, they just think that all lawyers are crooks and very expensive, and they're already starting to throw up the towel. Throw in the towel. And that's true because since this was announced on May 5th, published May 10th, my phone is ringing off the hook, Cigars and Sons included, from people in the industry, many of which I've never even heard of, and I know a lot of people in the industry, but they are people that run manufacturing facilities in Central America, the Caribbean, and they're freaking out because they just didn't have this knowledge. They're not on the blogs. They're not part of IPCPR. They're in the dark, and they're freaking out. So we're trying to help them out the best we can. So the past couple of months, we've been providing guidance to anyone who asks and calls us about what we think is going to happen, the resources that are necessary for them to weather the storm. And also, we're telling them, don't just worry about what the FDA deeming regulations are saying, but worry about everything that's in play. There's politics involved. There's possibilities of things in Congress that could change things. And then there's litigation. Litigation we filed on behalf of Global Cigars, HB2. We filed on June 1st, and then recently IPCPR we talked about, and CACRA filed an action. So it's possible that that litigation could change some things. We hope. And we hope that it'll be better for some of these small guys.
Yeah. So what's maybe strategy? How are you looking at approaching this whole process? I know you mentioned you had a few ideas of things, whatever you can tell us.
Yeah, sure.
I don't know how much of that stuff you have to keep hush hush.
No, I'm happy to share it, man. I mean, I won't disclose things that I can't.
Yeah,
it's obligated. But so our strategy, number one, inform people who are interested, as we've been doing, of what the deeming regulations actually say. Not the rumors, but what we've read the deeming regulations to say, what the few guidance documents that they've issued actually say. Okay? It's one thing to just read that, post it on a blog, and say, "Oh, this is what they say." The job of an attorney or anybody else involved in this is we have to figure out, okay, that's what they say. How does it apply to you? Yeah. Brian Hewitt, you have a chinchad, in a little small factory in Nicaragua. Tell me about your circumstance. How long you been in business? Do you have any grandfather products? Do you only private label, or do you have your own products? Are you putting them in U.S. commerce? When did you start doing it? How did you do it? Who did you sell to? Where did you advertise? Do you have any evidence of any of this? Because we go through that, they're shaking their head, They say, okay, I need invoices, I need dated advertisements, and prove to me that you have this. Oh, we don't have that. So I have a client, I'm not going to tell you who it is, but I just met with him recently. They've been in business for 35 years. Grandfather started it, and the grandson just took over about a year or two ago, and he came out, he revitalized the brands, and comes to us and says, we think we have grandfather products. I go down there, I go through all the documents, go through the old boxes, and I'm like, shit, we got nothing, zero to prove. Now, what do? I don't know. We try grandfather and just do like a declaration from his mom and other people over there saying, we don't have anything, but we think it's grandfather.
Will that be recognized, do you think, or is that kind of up in the air?
So they're looking for any type of evidence that would prove that the product was commercially marketed February 15, 2007 and prior. It'd be on that date prior. In the absence of that, they don't say what they would do, but they do make it broad enough where they'll consider anything. My position is all we have is testimony from 2009 years ago, that's all you're going to get. But I have no confidence in counseling a client that that's enough. So what I told him, I was like, this is what we're going to try. And I don't think it's going to go through. We hope it is, but you have to prepare yourself for the fact that it may be compliant or not enough. We have to do a substantial equivalence when you do new products and somehow find a predicate tobacco product that we don't need to. And then we have to go through that process. And then where are the documents for this? When did you introduce it? Where is it sold? So to answer your question, what we've been doing is educating people, giving them a form questionnaire that I designed based on the knowledge of what manufacturers do and the shortcomings they probably have them fill it out, and then we send them a spreadsheet and ask them to start filling out their blends, information about the blends, so that I get a sense not only who they are, but what they have to support their plans. And I'm not even charging for that, I'm just sending it out to get the juices flowing for them. And I'm telling people, let's just wait a little bit, before we start filing things, because we want to see what happens with litigation, we want to see what happens with legislation, and then 3, 4, 5 months down the road, if those avenues don't work, then let's start filing stuff. Let's spend your money then, but let's not spend your money right now.
So, I don't know how much you want to get into this, but like the cost of doing all these different things, like obviously the grandfather stuff is going to be the cheapest, maybe nothing, right? If you can establish it, maybe you're going to need to put a little time into do whatever it needs. But what are we looking at in terms of costs for various steps? Like somebody comes out with a completely new product now, they want to bring it out. What are they going to do? What's going to happen? What's the cost? What's going to happen?
Sure. So so the cost for a filing fee with the FDA, there is no cost. There's not a you file a trademark, there's a filing fee.
So I think that's a conception a lot of people have, that there's a $10,000 thing and the federal government's expecting a check.
No, they're not. No. You're going to write a check, you being manufacturers, are going to write a check to the government once your user fee is established. And that's going to be later next year. And that's going to be based upon your 2016 imports. They'll look at your S-chip, they'll look at your place in your category, long filler, short filler, whatever the case may be. And then they're going to come to you, they're going to go to your importer. Your importer's going to tell them what you imported throughout the year, then they'll do the math and they'll say you owe this for the fourth quarter of 2017 based upon your 2016 imports. And that'll change every year based on your imports. And we think that's going to be about 4 cents a stick.
Okay.
Estimates are between 2 cents and 6 cents. I say it's 4 cents a stick. So the math I've done, this is not filing, but it's not your user fee. If you're importing about 1 million cigars a year, you're probably looking at about a $40,000 a year user fee to the FDA. Paid quarterly, so it'd be 10 grand, 10 grand.
Okay.
Yeah. As far as actually compliance with FDA filings, grandfather, substantial equivalence, exemption of substantial equivalence, there's no filing for the government. You're paying me. You're paying the lawyer, paying for our time, paying for the back and forth, all that. And the pricing, we have significantly lowered it from New York or DC Council based on our 15 years in the cigar industry. We know things that it would take another law firm $10,000 to figure out. We have that in our archives. We have a library of information that we've had, and we just developed over time. So that's why we think we can do it for cheaper. We're still going to charge you something that you don't want to pay us. We're talking a couple $1,000s per application for grandfather, and 5 grand, 7 grand, 8 grand possibly for substantial equivalence. There are different types of substantial equivalence applications as well. There's like characteristics and quantity change ones, which are much more they call them the streamlined applications. We think our prices will be a little lower on that. And again, we're probably going to lose on some of those, but I think we'll gain on some others. But on average, I think it's fair for the industry because based on the volume that we'll do and our knowledge.
So that the one you were mentioning first is like a packaging change, basically. A few more sticks in a box, or change to the band type of thing, and that's a streamlined deal.
Yeah. So say you have a grandfathered XYZ brand, Brian's Bearded brand, whatever it is. It's
wonderful models,
and it's a grandfathered. No question, it's grandfathered.
Yeah.
But in 2009, 2010, for some reason, you shaved or you change the packaging.
You shave the band,
right? And you're gonna have to do substantial equivalence. And so you get substantial equivalence for that packaging. But maybe for some reason, a year later, you had a 20 count, you went to a 25 count. that application would be streamlined based on the substantial code streamlined procedure, and that would be much cheaper.
So you could, if you wanted to, you could go back and use those other packagings if you wanted to with no additional fee, because you've already done the substantial equivalents for those in the past. Is that correct?
That there would be a much more reduced fee.
So there still is, even if you just, hey, we're going to
charge you for anything we do.
That's a good extension. Yeah, that's a good. If you're doing legal work, of course. That's what you do.
I've done a lot of free legal work in my time.
Oh yeah, I know.
So if it's something that we find, you did something very minor, and we already have something on file for you, we've done it, and all this is changing a paragraph or a quantity, I can't in good faith charge you $5,000 a week. So we'll charge you something significantly less than that. And depending on what size client you are for us, we may not even charge you for that. The same model we use for trademarking, why half the industry uses us, is the same thing. Be fair, don't screw your neighbor, just try to do good work, and don't kill people on fees. And if they feel like they got a good service for a good price, they'll come back to you and refer other people to you. And that's worked for me.
Well, speaking of referrals, if somebody wants to contact you, I'm assuming you're willing to help anybody, how do they get a hold of you?
So, cigarlaw.com. Unfortunately, I haven't published a post on that in like a long time. The firm's called hnewmedia.com. A lot of people think it's a stupid name, but it's worked for us. So, hnewmedia.com. That's it. And just Facebook, Twitter, whatever.
Okay.
Tinder.
Yeah, Grindr maybe.
Grindr.
Yeah. Disregard that. I don't think that'll fly well in some certain circumstances, but and so anything else? I mean, any other misconceptions or things that we need to know?
There's lots. We get a lot of so we get different types of misconceptions or questions, and it's just a dude like you that reads everything but just doesn't understand how
not a lawyer. Yeah, not gonna get it,
and that's why you hire someone like us, because that's what we do. I'm not a mechanic. My brother is. He's a fine mechanic. I don't know how to change the oil in my car, so I'm happy to pay him to do it. And then you get people. Our biggest problem is Central America, South America, Caribbean manufacturers who just don't speak the language. And I speak Spanish, and our staff speaks Spanish, so we have to translate that. So, I read this, but you have no idea what you're talking about. So, the greatest misconceptions are grandfathered, what it takes to prove that. Substantial equivalence, what does it mean? We don't even know what that means, okay? The FDA, I don't think, knows what it means for cigars. Cigarettes have already gone through it to a certain degree, but that's going to be a big question for me.
Will you be able to use any of what happened with the whole cigarette process to help out with this? I mean, are you going to be able to rely on that to help you, or is it going to be a hindrance, or is it just not at all related?
Well, everything's related, especially when we're talking about tobacco. So we'll look to what the cigarette companies have done. We have looked, because it's all on the FDA's website, as to their marketing orders, what they've accepted, what they haven't accepted, that type of thing. But what we've learned from that process is give the FDA what they're asking for, basic information. Do not provide any information that was not asked for. It's our burden to prove certain things, but we're going to give them the bare minimum, let them come back to us. Because our concern is people who do not understand this industry will provide irrelevant information that may throw the FDA off into kind of a witch hunt, or just trying to
that would be bad.
Yeah, and that's really our greatest concern.
Yes and no answers to all questions.
or maybe. Yeah, maybe.
Yeah. I'll get back to you.
Yeah. So, we could sit here for days, but I don't know who's going to sit through this long interview. But
I think some people will be interested in it, because I think that I don't think I completely understood it. I learned a lot just talking to you, on camera and before about what's going on. It's just people don't know.
Yeah,
I think people are interested. Anybody who's into the cigars is going to have to be curious. Is what's really happening? We know a lot of people get really angry and post stuff on Facebook and various things. But that doesn't tell you.
Yeah, most people just don't understand what's going on.
Right.
Or there's so many, like we said, misconceptions out there that there's a lot of bogus information or misconstrued stuff out there.
I deal with it all the time, and I read all that stuff too, and it frustrates me.
Yeah.
It's really frustrating because, it's just frustrating, and that's it. But we're hopeful our litigation is successful. We asked, we have several counts. If we win on one count, I feel like we've done our job. IPCPR's got a lawsuit. If they want to work together, I'm happy to work together. Let them take the lead. But they've just not reached out to us at all, which is unfortunate. We hope a federal judge, either in Southern District of Florida or DC, reads this and says, the FDA just rushed this through. This is ridiculous. I mean, you have to have some well-reasoned, deeming regulations that affect a large part of the small business industry. The Regulatory Flexibility Act is one of those that they violated. We know they violated because they didn't listen to the SBA. The SBA is the Small Business Administration, said, you're going to decimate this. And they said, yeah, fuck you.
I've never heard of that before. The Regulatory
Flexibility Act.
Flexibility.
It's known as like the Small Business Act.
Okay.
Essentially, you can't. An agency cannot issue regulations that have a disproportionate effect on small businesses. If they do, there has to be a well-reasoned analysis as to why it's important, why it's necessary, 100% necessary. And it has to be based on science or reason. And they're basically just saying, "Oh, the public health, It's like, well, they cite a bunch of studies, but not for cigars. They don't. The studies that they show don't show that that balance is there. That they've met their scientific or the burden to provide scientific evidence to disproportionately affect small businesses. This whole industry is small businesses. You got your big guys and all that, and they're going to be fine.